Okay. Very good evening, everyone. Good evening, students. So, first of all, I welcome each one of you to my class on the investigation, and we are discussing CRPC. So, today we are going to solve some of the important MCQ in relation to the topic investigation. So, let's start with my brief introduction first. My name is Sandeep Khatri. These are my areas of specialization, as you can see on the screen: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, this is the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me and ask your questions related to your judicial preparation. This is my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. Okay, ji? So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So today we are going to solve some of the MCQs in relation to the topic investigation. But before that, if you have any questions in your mind, you may ask, and if not, then I'll start the MCQ test. Very good evening, Priyanka, and everyone, those of you who have just joined. Okay, so I hope you all are ready. On that note, let's begin with the test. Here comes the first question. Just a humble request before starting the test that whatever your answer is, so for example, if you are answering for question number 1, first do write down the question number 1 in the numeric, and then whatever your answer is, A, B, C, or D. So make sure you mention the question number as well. Here is your first question. Information to the police and their powers to investigate under chapter. So basically, chapter number has been asked. Okay, Priyanka, correct answer. So students, it's a direct question. So it is basically chapter number 12, and starting from section number 154 till section 176. The term investigation has been defined under section. Sonali, Sumati, correct answer. Next one. The term investigation has been defined under section. Okay, first one to answer correctly, Sumati. Yes, section 2H is the correct answer, students. So C is the correct answer. Information in cognizable offences under section. Sumati and Priyanka, correct answer. Naz Pasha, please do correct your answer. Section 155 is for non-cognizable offences. Okay, so the correct answer here is 154. Okay. FIR under section 154 can be in. So once the FIR has been lodged, that can be in oral, written, discretion of police officer, none of the above. Okay, Priyanka is answering D. Ashmita is answering C. Students, the correct answer here is B. FIR under section 154 can be only in written form. Now please listen this carefully. The information which is given by the informant, that can be in oral or written form. But when you say FIR, the first information report under section 154, that must be in written form only. Okay, so the correct answer here is B. I hope everyone is clear with this one. Okay, next one. Which of the following statements are incorrect in relation to FIR? Okay, Priyanka, Ashmita, Sumati, and Naz, please do correct your answer. Now listen carefully. Which of the following statement is incorrect, which means wrong, in relation to FIR? The very first statement, shall be signed by the person giving it, which means the informant must sign. It is mandatory on the informant that whatever information he has given under section 154, that shall be signed. This A statement is completely correct. Every information is relating to cognizable offense. This is also correct. So A and C, both statements are correct. May be signed by the person giving it. So it is not the discretion. So this one is the B is the incorrect statement in relation to FIR. Okay. You may read section 154 clause 1 for the confirmation. The term shall has been used under section 154 clause 1. Next. Who may lodge the FIR? Who may lodge the FIR? Sumati, first one to answer correctly, followed by Ashmita and Priyanka. D. Ramveer, please do correct your answer. Naz, correct answer. Students, who may lodge the FIR? The correct answer is any of the above. The child, the woman, or the witness. Any person can lodge the FIR. Can anyone tell me why any person can lodge the FIR? Anyone knows the reasoning why any person is allowed to lodge the FIR? Yes? Anyone? Be quick. And if you don't know, please do write down in the comments that you don't know the answer so that I can explain. There are two reasons why any person can lodge the FIR. The very first important reason is because to make the criminal law into motion. Okay, this is one of the most important step, and that is why any person is allowed to lodge the FIR. The second one is it is not a substantive piece of evidence. The overall objective of FIR is to make criminal law into motion so that the police get into the action. So the police will further submit the report to the magistrate. Then the magistrate will start the inquiry. Then it may then the trial may take place. So it all depends upon whether the FIR has been lodged or not. That is why any person, and it is, again, it is not something which is a substantive piece of evidence. So that is why anyone can lodge the FIR. Next one. FIR defined under section. Which section defined the term FIR? First Information Report. Priyanka A. Divya D. First one to top three students to answer correctly: Divya, followed by Sumati, Ashmita, and Naz. Okay. Priyanka and Ram, please do correct your answer. Section 154 does not define the term FIR. Okay. So this term has not been defined. Okay. Even when you will read section 154, even FIR term has not even been used in that section. Okay. If three offenses has taken place and one out of those is cognizable offense and others are non-cognizable, then the case shall be treated as Sumati, Divya, and Ashmita. Correct answer. Students, if there are three offenses and one out of those is cognizable offense and even other are non-cognizable, that whole transaction, okay, that whole transaction will be treated as cognizable offense. Okay, so FIR A will be lodged. Okay, NCR is basically section 155. This is question from section 155 clause 4, which confirms that. Okay, so A is the correct answer. The power to direct investigation under section 156 clause 3 of CRPC can be exercised by top three students to answer correctly: Divya, followed by Sumati. Okay, when you read section 156 clause 3, the power is basically exercised by the magistrate. So B is the correct answer. If offense under section 376 IPC is committed, the information shall be recorded by first one to answer correctly: Naz, followed by Jojo, Sumati, and Priyanka. Students, D is the correct answer. And this you can read under section 154 proviso as well. When the offense of rape has been committed, then the victim is going to be more comfortable in front of a woman police officer or any woman officer in comparison to any male officer. Okay, so the answer is D. Which one is incorrect in relation to FIR? FIR is a substantive piece of evidence. Informant need to be eyewitness. It is not a substantive piece of evidence. Both A and B. Sumati, read the question carefully. The question is incorrect. The question is incorrect in relation to FIR, which means which is not correct. Okay, so if it is saying it is not a substantive piece of evidence, this is a correct statement. FIR is not a substantial piece of evidence. Okay, so A and B both are the false. So D is the correct answer. Okay, informant need not to be eyewitness. We have just discussed this provision in the previous question, that the woman officer shall record information of rape being given by the rape victim under section. Students, a humble request, please do write the question number before your answers, because I think there is going to be a mix up. So please do, whatever your answer is, A, B, C, or D, first please do write the numeric question number like 12, and then whatever your answer is, A, B, C, or D. Okay. Okay. Sumati and Priyanka. Sumati and Priyanka, correct answer. This is basically section 154 we are talking about. Okay. So C is the correct answer. Which is true from the following in relation to FIR? Yes, you must not take that much of time. Okay, first one to answer correctly, Sumati. Yes, Sumati, first, which one is true? So FIR is only a report about the commission of crime. This is completely correct. This is basically the meaning of this term FIR. Now, police officer have to take prior permission of magistrate. Now, this is something which is in the cases of NCR. So that is why this is incorrect. The police officer has all the powers to start the investigation even without the prior permission of magistrate. Okay. Similarly, police officer cannot arrest. Yes, police officer can arrest. Okay. So this is false. Police officer cannot arrest. This is false. Police officer can arrest without prior permission of magistrate after lodging the FIR. Why? Because FIR is in the cases of cognizable offences. And when you will read section 2C that define the term cognizable offences, what it says, that the police officer has all the powers to do the arrest even without the warrant. Okay. So A is the correct answer. Occurrence report under section. Which section defined the concept of occurrence report? It's okay, Priyanka, you don't need to be sorry. You are in a class, you are here to learn. So you're allowed to do mistake. But just make sure that you will not, you see, the benefit of this class can be like you are not going to repeat these mistakes. And especially when it comes to your, in examination hall. So that's the idea. Sumati, Priyanka, and Naz, please do correct your answer. Okay. Occurrence report is defined under section 157. Okay. Section 157. And what is the formula of occurrence report? Or basically, or you can say, what is occurrence report? Occurrence report is basically the copy of FIR plus, in addition to that, the endorsement of the police officer, whether the police officer is investigating the case or not. And if the police officer is not investigating the case, he must mention the reasons for that. Okay, what are the reasons why he is not investigating the case? So this is basically occurrence report. And what is the objective of occurrence report? Through occurrence report only, the magistrate will get to know, okay, some FIR has been lodged and what is the position of investigation, whether the police officer is investigating or not. And if the police officer is not investigating and magistrate is not convinced with the reasons given by the police officer, then the magistrate may issue a statement to the police officer and he needs to start the investigation. Okay. So this is basically your occurrence report. Magistrate has all the powers to direct the police officer to investigate in respect of an offense, and that particular offense is under IPC, under local law, under special law, or all of the above. Gaurav, please do a quick refresh. Right now we are on question number 15 and you are answering for question number 12. So just do a quick refresh, okay? Okay, first one to answer correctly, Naz, followed by Mohammed, Sumati, and Priyanka. Everyone's answer is correct, and that is all of the above. See, students, whether it is your local law or your special law, okay, CRPC will be applicable to that. You can refer section number 4 of CRPC for this as well. Okay, so unless and until there is a special procedure of investigation has been given in local law or special law, this CRPC will be applicable on IPC, local law, and special law. So the answer is going to be D, all of the above. A non-cognizable investigation starts. When the investigation will start in the cases of non-cognizable offences. First one to answer correctly, Kavya, followed by Sumati and Amandeep Singh. Narsing Yadav, please do correct your answer. Okay. In the cases of non-cognizable offenses, okay, investigation starts only after obtaining the order from the magistrate. So B is the correct one. Okay. Rest one is Naz and Priyanka, correct answer. A copy of FIR shall be given dash to the informant. Fill in the blanks. Top three students to answer correctly: Amandeep, Kavya, and Gaurav. And everyone's answer is correct. Sumati and Naz, Devya. Okay, everyone's answer is correct. That is of free of cost. Investigation as to non-cognizable offense under section. You should not take more than 2 seconds to answer these kind of questions. These are the most basic question you can expect in your exams. Okay, Kavya, Sumati, and Mohammed, top three students to answer correctly. And yes, section 155 is the correct answer. Occurrence report submitted under section. We just discussed occurrence report defined in the section. Okay, in which section we have just discussed in the previous questions. What is occurrence report? I have already explained. So now occurrence report submitted under section. Divya Tiwari, only student to answer this correctly. See students, read the question carefully. Occurrence report submitted. So submitted under section 158 and occurrence report defined under section 157. So this is the difference between these two sections. 157 defined the concept of occurrence report and 158 is how the report is going to be submitted. Okay. So there is going to be a role of SP as well here while the submission of the report. Under section 154 clause 3, you may send in writing by post to the dash for lodging the FIR. So basically, once the police officer is not lodging the FIR, then the procedure is laid down under section 154 clause 3. So who you may approach under that section. Top three students to answer correctly: Gaurav, followed by Kavya and Amandeep. And everyone's else answer is also correct. Muhammad Yusuf, please do correct your answer. Superintendent of Police is the correct answer. C. One of the landmark judgment you can expect in your PT mains examination. Lalita Kumari versus Government of UP 2014 Supreme Court is related with. There are certain guidelines that has been issued by the Honorable Supreme Court in this case, which are very, very important. Starting from Gaurav, everyone answer. Kavya, Naz, Divya, Nursing. Everyone's answer is correct. Ramveer, please do correct your answer. It is not on the appeal, it is basically on FIR. Okay, so This is a landmark judgment where Supreme Court confirmed that first you must lodge the FIR, and after that the police officer should start the investigation. Okay, and it is mandatory on the police officer that once he got the information about the cognizable offense, he must lodge the FIR. A boy aged about 14 years is suspected in a commission of an offense of murder. He can be made to join investigation. Choose the most appropriate option. Okay, top three students to answer correctly: Sonali, Amandeep, Gaurav, Naz, Mohammed. Okay, ji. Everyone's answer is correct. That is basically at his residence. Okay. So basically, because of that age of the boy, the police officer should not call him to the police station to just avoid any kind of completely different experience. Okay. Those of you who have personally visited for at the as you are doing your internship or at the time of your practice, you may understand that, and you can easily relate that it is not good that the boy aged of 14 years is called to the police station. Which of the following may record confession under section 164? Section 164 is the only section that deals with the concept of judicial confession in your CRPC. Kavya, Amandeep, Sonali. Everyone's answer is correct, followed by Sumati, Gaurav, Naz, Devya. Okay. So the answer is judicial magistrate first class, or you can say the metropolitan magistrate. So as far as the other options are concerned, A is the most appropriate answer. Okay. So A. Yes, completely correct, Gaurav. It's a judicial magistrate only. One more thing, students. Usually, students ask, sir, when we read section 164, the term magistrate has been written there. Okay. So, what you can do is you can follow section 3 of CRPC as well, which makes this concept clear that we are talking about judicial magistrate, not the executive one here. So, the answer is E. Maximum period of police custody by magistrate. This is basically under section 164. Amandeep, Kavya, Sonali, and Divya, Gaurav, Ram. Correct answer. Naz and Mohammed, do correct yourself. It's 15 days. Okay. Understand. You can read section 167 as well. And similarly, in the same section, maximum period an executive magistrate may authorize the detention of an accused in the custody. So, this is basically in those circumstances when the judicial magistrate is not available. So, the police officer has also an option to approach the executive magistrate. But obviously, because of the nature of the executive magistrate, the powers are less. Okay, Sumati. Gaurav, first one to answer correctly, followed by Kavya, Sonali, Naz, Sumati. Everyone's answer is correct. Okay, ji. Ram, correct answer. That is maximum 7 days. The accused has indefeasible right, which we say by default, which means accused by default will get the right to bail when investigation is not completed within. Kavya followed by Gaurav, Sonali, Amandeep, and Naz. Everyone's answer is correct. That is 90 or 60 days. That basically depends upon the nature of offense that has been committed. So C is the correct answer. Case diary is under section. Yes, Gaurav, default bail. Amandeep, Kavya, Naz, Sumati, Divya, Gaurav, Ram. Everyone's answer is correct. That is B. 172. Who will forward the occurrence report under section 157? Who will forward the occurrence report? Gaurav, Kavya. Correct answer. Divya, please do correct yourself. Naz, please do correct yourself. Sumati and Ram, correct answer. Divya and Naz, who will forward? Which means who will send the occurrence report? Police officer will send the occurrence report. To whom? Then the answer is going to be magistrate. So from police officer is the one who is going to make the report, and then he will forward it to the magistrate. But here the question is who will forward? So police officer will forward. To whom? The magistrate. Investigation after lodging the FIR by the police officer is dash under section 156 clause 1. Gaurav, please do correct yourself. In Lalita Kumari, it was held that the FIR shall be lodged, not the investigation. Okay? When you will read section 156, you will get to know it is the discretion of the police officer. We are talking about investigation, not about lodging the FIR. Investigation after lodging the FIR by police officer is. So, what is the status of investigation? It is the discretion of the police officer. Okay? What is mandatory? Mandatory is the lodging of the FIR is mandatory as per to the Lalita. So, the correct answer here is B. Okay? So, everyone, please do correct your answer. The correct answer is B here. Last question. Under section 164, recording of. What do you record under section 164? Kavya, Gaurav, Amandeep. Sorry. Kavya, Gaurav, and Sumati. Correct answer. Ram, correct answer. Amandeep, please do correct yourself. 164 is not only about confession, it is also It also includes statements as well. So yes, C is the correct answer. So anything before concluding the session? If you have any question in your mind, you may ask. This is the link of my profile, my Telegram channel, and this is my code Khatri10. So let's crack PCS J with Unacademy. This is an exclusive offer which you can save up to 25% on the 3-month Judiciary PCS J subscription. Okay, this offer is valid from December 19 to 21. Yes, students, anything which you are not clear with? Chaliye. On that note, this is the revamped test series which Unacademy is offering this December. This is the Bihar State Judiciary batch which has been recently started from December 8th. This is the batch which has been started from December 15th, Judiciary Legends UP batch. This is the Unacademy subscription for Plus and Iconic. This is the Articulate and Initiative by Unacademy coming soon. These are the YouTube channels of Unacademy. These are the Telegram channels of Unacademy. And that's it from my end. See you in my next class. Till then, yes, it's time to say peace.